Well, good afternoon, everybody. Good afternoon. My name is Ross Sandler. I'm professor of law and director of the Center for New York City Law here at New York Law School, and I welcome you to our building here and to the Ethics Law in New York State Continuing Legal Education Program. I'm delighted to see so many people here. It's been a lot of hard work, particularly at JCOPE, to put the program and the materials together, and it really makes it all worthwhile when so many people come and learn and enjoy this program. I'd like to thank a few people who have worked so hard. First at the law school, Brian Kasuba, the Associate Director of the Center for New York City Law, Jesse Deno, Lillian Valle Santiago, and Shelby Hoffman, all of who you've probably met as you came in, and they've been the ones who worked so hard here at the law school. I'd also like to thank particularly at JCOPE, Pepe Chang de Castro, former fellow here at the Center for New York City Law and a good friend who has really been the connection to JCOPE and New York Law School. And we thank them so much for choosing us. This, of course, is a major effort of the law school. We have, for the last 22 years, sponsored the Conflicts of Interest annual seminar with the New York City Conflicts of Interest Board. Many of the people from that board are here today, and we do that every May. We have up on our website, City Admin, all of the New York City conflicts of interest enforcement actions and advisory opinions, and we also now are beginning to put up JCOPE's material as well as our site, as on their site as well. So we're delighted to be here at New York Law School, part of the world that is interested in conflicts of interest in ethics and government, and hope that we are part of that constructive side. I'd like to also now introduce Seth Agata, who is the executive director of JCOPE. You have his biography in the materials, but I'd like to say that he has experience in almost all the branches. He was counsel to the governor, worked in the assembly, and the controller's office has now taken on this important responsibility at JCOPE, and it's done two important things I want to call to your attention. First, you all received a copy of City Law, and we were fortunate enough to have Seth do a cover article for us, which is a terrific article on the 2016 amendments, and I hope everybody got a copy of that. It's a really helpful article. And then Seth, with Pepe, has inspired JCOPE to publish this wonderful desk book, which you're all getting. This is the first time it's been published, first edition. You have maybe you should get Seth or Pepe to sign it, because it is a first edition. It's part of what we tried to do here at the law school. We have a desk book that we co-sponsor and co-publish with Conflicts of Interest Board for the May program. And we think it's really important to have this kind of material on people's desks to be able to refer to and learn from, and part of the training. And I have read every word of it. It is a terrific book, and they really deserve a great deal of congratulations for producing a first-rate book that's going to be very helpful to people in government. So with that, I'd like to bring to the podium Seth Agata, who will be the executive director and give the first speech.
Thank you. You know it's going to be quite a presentation when the speaker takes out a watch to make sure he doesn't talk too long. So that should be a warning sign. I'm going to do some thanks right off the bat as well, if I may. I'd like to thank New York Law School for working with the Joint Commission on Public Ethics and putting this together. This is going to be the first, I hope, of future seminars that we can run. And in terms of publications as well, working under their auspices has been tremendous. I'd like to certainly thank Professor Sandler. I'd like to thank my commissioners. We have 11 out of 14. There are 3 vacancies left, so, you know, speak to those appointing authorities and sign up. But our commissioners who we work for as staff in the commission, and ultimately get credit, get blame, and take responsibility. I'd like to also thank a tremendous JCOPE staff. The people I work with, I think, are some of the finest people I have ever worked with in government. That includes our General Counsel, Monica Stam, Martin Levine, a number of folks, and she asked me not to mention her name. I will not mention Pepe Chang de Castro's name, so it has not been mentioned. But she has helped guide this through and has just been absolutely wonderful and creative and a driving force in getting this together. Just also as another preliminary to let you know that not only are we having this seminar, but Monday we're going to be having a public hearing in Albany for something that's somewhat historical in New York State ethics. We're going to have a public hearing under the State Administrative Procedure Act on lobbying regulations. So for the first time in New York State, we will have a codification, some form of codification of all of the lobbying jurisprudence, advisory opinions, advice, and other extraneous material that's out there that makes up what guides JCOPE in adjudicating and governing, regulating lobbying in New York. It's open to the public. Our comment period expired October 16th. But if there's some written thoughts that you have, we're welcome. It is a public process, and we aim to be as public and as transparent as possible. Once again, Professor Sandler talked about the book. It is for sale in the lobby. Well, it's not really for sale. That's an ethical lapse on my part. But if it really is, it's a very helpful book. And seeing what a fine job COIB has done with their volume, I think helped inspire us to produce a similar, hopefully a similar product for the state ethics and lobbying law. What I hope to do is give a good lead into Richard Rifkin's talk about why we are what we are today in terms of ethics regulation in New York State. And what I'd like to do is give you a brief historical overview and ask a couple of ask and maybe answer some fundamental questions as to why ethics is regulated the way it is regulated in New York State. And it's sort of an organic, basic question. I think, and I was wondering how to deal with this because just this morning I looked at the Wall Street Journal and there's an article about some building inspectors taking bribes. So there's obviously, and we hear everything else in the paper, things that are, that perhaps internally we consider outrageous behavior, that the press considers outrageous, that the public considers outrageous for good reason. And I see the language that has come up with some groups calling it a culture of corruption in government. I'm going to suggest that that's not accurate. And I'm going to suggest that for most of the 200,000 state employees that you deal with, and there's city and municipal employees out there as well, but I could certainly talk about the 200,000 or so that we have responsibility over. I would characterize it more as a culture of compliance. I think most of the I would suggest that most of the dealings the public has on a day-to-day basis with government is not necessarily with an elected official. It's with the person that you'll see at the Department of Motor Vehicles, requesting a birth certificate from the Department of Health. There is no, in the state employee level, a culture of payola, of bribes. You talk to people from other societies and other communities, there's a feeling to get something done, you've got to grease the wheels. In reality, that's not really, I would suggest that's not the case, and I think that the public doesn't believe that that's the way all of government runs. I know as far as, for example, at JCOPE, we do a number of things, but in the area of ethics regulation, we offer advice to public employees. We get 10, 12 calls a day. People asking us, what is the right thing? What should I be doing? I don't want to step on a line. Or, first of all, they may ask, is there a line on my behavior? And we'll be hearing about some of those lines in the context of post-employment activities. But the mentality is, how can I do this right? And I think that is the culture that does pervade New York State government at that fundamental organic level. There is an expectancy of honesty and integrity, which I think is why the public gets, and should be, as shocked as it gets when it hears stories of bribery, of self-dealing, of perhaps outrageous nepotism, all the kinds of things that we think of when we think of conflicts of interest and of unethical behavior. Illegal behavior aside, bribery and if you're in the Fed sector doing with honest services, those things are crimes. But we're talking about perhaps behavior that falls in the cracks. Is not a crime, perhaps it's not enough to remove someone from office, but it's still something that we consider unethical. I think the ultimate forum where that will be decided is not going to be within the ethics laws, but it's going to be within the election laws, where one can change that at top through campaign finance reform, ballot access, non-ethics questions. In other words, changing the mentality at the top to kind of recreate what the Romans called, and I can't do Latin because we didn't do Latin in my shul growing up. It was called civic virtue. I can't pronounce the word. I say civitas or civitas if you speak Latin. When that comes from the top, and it's there, I think with most of the folks that are at the top, if not all, well, I won't say all, but a good many of them, I think that will address ultimately the concerns that perhaps make most of the headlines. What I'd like to do for you is explain why we have what we have in place now, given what I've just said. We didn't sort of just land in place with JCOPE or with its predecessors, COPE and the State Ethics Commission. I'd like to give you some historical context for appreciating where we are, and I think what Richard will do is pick up on setting that description of exactly where we are now and perhaps showing where we might be going. New York State ethics legislation, executive orders, the whole realm of the way we regulate ethics really has three fundamental components that are all coupled with enforcement mechanisms. First, there are prescriptive codes and behaviors. Our public ethics law is not like what we have governing us for the rules of professional conduct for attorneys. They're all thou shalt nots. The rules for attorneys are a lawyer should provide competent representation. A lawyer should act with reasonable diligence and promptness in representing a client. We don't have that in the public ethics, in the Public Officers Law, Section 74. It's mostly proscriptive language, setting boundaries on behavior. In fact, I think the most, and this will come up very shortly when I talk about enactments during the Rockefeller era, public employees take an oath. They will affirmatively uphold the Constitution. That is their oath, and that becomes certainly a very key aspirational goal. The second, in addition to the codes, is transparency. We have the idea is that sunlight solves a lot of problems. That's our lobbying regulation for the most part. Those are our financial disclosure regulations. Coupled with each of these, by the way, is the idea is if you don't do it, there is enforcement. And then finally, there's education, which is why we're here today. It goes along with the idea that public officers want to do the right thing. These are not constitutionally based. I know there's discussions with the upcoming vote on the Constitutional Convention about embodying in the Constitution, but the Constitution as an organic source for this is not really there. Constitutionally, there are ways of getting rid of public officers who don't break the law, who do something bad but don't commit a criminal act. There's impeachment. The Attorney General still has, under 63, quo warranto, can remove an official. I'm always amused that the way the British or the English did this back in at least the 1700s was through bills of attainder, where you would have Parliament actually vote someone guilty. chop off their heads, take their money, and that would be their judicial finding or legislative finding of guilt. That's something that's obviously banned. It was banned up front in the federal Constitution. But transparency was the first mode of ethics regulation in New York. It goes back to the formulation of the Moreland Commission in 1905, 1906. There was something called the Armstrong Committee. You read the report, and a lot of this is in the first chapter that I wrote in the book. And if you don't fall asleep during it, at least you're hearing it from me now. It criticized lobbyists, and the quote's great, for the employment of agents to disperse large sums and of clandestine methods to defeat legislation. Such conduct is wholly unexcusable. This was back in 1906, and there were scandals involving insurance companies and other entities, big money in those days, big money now. And the solution that the Armstrong Committee came up with was the first lobbying regulations in New York. Other states had done it first. Wisconsin, Massachusetts, Wisconsin having a long progressive tradition, New York not having such a long progressive tradition. But necessity mandated, and they mandated some changes, and through Department of State, there was mandatory registration of with a description of lobbying, an essential register of people spending money to change laws back in 1906. That satisfied a lot of the good government groups to a point. Things got fairly nasty, again, during the administration of Governor Dewey. And it was during Governor Dewey's administration that we have our first code of conduct, which is now was 74 in the Public Officers Law. It also included Section 73. I'm kind of amused as we deal with post-employment issues coming up. The violation for the 2-year bar was considered a misdemeanor. There's no record of it ever being enforced, but it was a misdemeanor, and it was considered serious enough by Governor Dewey and the legislature. It rose out of a scandal with a fellow by the name of Senate Majority Leader Wicks. I think we've heard that name for those of us who've dealt with the Wicks Law and related matters. First step at a legislatively mandated code of conduct. Governor Rockefeller called for a Moreland Commission in 1962. There were another number, once again, of legislative figures involved with a variety of nefarious activity. Nothing, well, I wouldn't say nothing. At the state level, the state executive level, nothing much came of that. At the legislative level, it led to the formation of the first legislative ethics committees in each house. They had separate codes of ethics. They had their own financial disclosure statements. There were new crimes created, which still exist in the Public Officers Law, none of which, at least going back at least 15 or 20 years, have ever really been enforced, but it's because we have other penal law crimes that deal with things like accepting fees for performing lawful duties as a legislator. There's something that looks like bribery. It is bribery. There's a Public Officers Law bribery crime. What's kind of interesting is the debate there generated a lot of press, and you have some interesting observations. The one that I enjoyed was Rabbi Alfred Friedman, who is chair of the Legislative Committee of the New York Board of Rabbis. He was asked, can't we just amend the oath of office to take care of all this wrongdoing? So people do something wrong, they've now violated their oath of office. He specifically said that laws need to be strengthened, and his reason was it's to educate and guide the uncertain conscience of some legislators who are presently unclear as to whether the taking of a gift from those who do business with the state or are regulated by the state is morally wrong. A little touch of sarcasm there, but it was certainly complemented by Robert Moses, who took for those of you who have read Robert Caro's book and are otherwise familiar, he called it this conflict of interest hysteria. It's going to drive out of politics and even government essentially decent people, especially young and struggling lawyers. But he did say, and it's interesting because I think there's a great deal of truth to this, mental honesty is needed, not a rigid moralistic code, well, advocated by do-gooders or by politicians who have pushed away the ladder by which they rose. So he doesn't like ungrateful politicians asking for reform. Takes us to the Watergate era in the 1970s. At this point in New York State, we have a code of ethics. We have 73, we have certain bars on behavior, outside activities. We have lobbying regulations in place, or the beginnings of lobbying regulation. Watergate prompted Governor Carey, when he couldn't get it out of the legislature, to promulgate an executive order mandating financial disclosure and barring conflicts of interest as a matter of law in a variety of areas for every member of the executive branch. That was struck down as unconstitutional in a case called Rapp versus Carey. But what was left was the governor redrafting his executive order and doing things that are similar up to the point where Richard will pick up on. An executive order that dealt with people who were administratively were appointed by the governor, served at his pleasure, bars on all political activities, and the Court of Appeals had some issues with that, and bars on outside activities, mandatory financial disclosure for anyone earning over $25,000 a year. That stayed in place until 1987 in one form or the other. There was something called the Board of Public Disclosure. Governor-appointed board. The first chair of that board was retired Chief Judge Desmond, and there was a board member by the name of Mario Cuomo on it, who was Secretary of State at the time. Brings us up to the Cuomo administration in 1987. Scandals. There was a joint state-city commission known as the Sovereign Commission, named after Michael Sovereign, the then dean of Columbia Law School, which in turn recommended a nonpartisan commission to investigate all government corruption. That's state and municipal corruption. Ultimately was established was what we now call the FIRA Commission, originally the Califano Commission. The legislature did not like former Secretary of HEW, Califano, on it because he wasn't really a New Yorker. So Dean Furek of St. John's Law School became the chair. Set up under the Moreland Act. They released 20 reports and led to 1987's very first Ethics in Government Act. And for those of us who were in government, something the public doesn't always see is the Government Accountability, Audit, and Internal Control Act, whereby we have to do audits every few years of our functions. Interestingly enough, in enacting that, part of the compromise was taking away the misdemeanors for 2-year bars, and there was a compromise reached with the legislature, as compromises must be reached when you do have a democratically run system where, in fact, and it's been criticized in the papers, you have individuals who are governed by the laws making those laws. We call that democracy. And part of that compromise was that financial disclosure statements, filing a false financial disclosure statement, is not a penal law felony, or penal law misdemeanor or felony. Separate crime under the public officers law. Eventually, during the Spitzer administration, I'm going to run out of time because I'll let Richard pick up on this, the 2011 PERA, the Public Employment Ethics Reform Act, took what was out there. There were various iterations of a state lobbying commission compressed with the State Ethics Commission. That was a consolidation to create JCOPE, the Commission on Public Integrity. And the Legislative Ethics Committee was replaced with something called the Legislative Ethics Commission. Each house has a committee. There is an overarching Legislative Ethics Commission. There were various attempts of reform during the Patterson administration. Again, not much accomplished in that area. Governor Cuomo's administration came in with what they viewed as a mandate to revamp things, and there was further consolidation. Investigative function of the Legislative Ethics Commission combined with JCOPE, or to form JCOPE, so that there would be some joint branch oversight of investigations of people subject to the Legislative Ethics Commission, and various other changes, including changes in bribery laws, expansive financial disclosure, once again emphasizing transparency. And so the mode of transparency, enforcement, and education, and by the way, steeper education requirements as well, as those who may be receiving notices of failure to take their training may know, that was part of what was going on in the administration over a series of 3 or 4 sets of reforms all the way through 2016. I'm going to let Richard pick up at this point. I'm just going to leave you with a thought. It's a sort of an evolutionary process. We haven't solved the problems of dishonest people who do dishonest things. Those people are actually subject to the same laws that we're governed by. We're dealing with folks who are in unique government positions, no matter what that position is, and have their own governance by us for ethics. There's a quote that Dean Furek picked up on in his report that I picked up on and followed up with. Dean Furek's report, talking about the way we've progressed in the area of ethics law, quoted Martin Luther King saying, "Morality cannot be legislated, but behavior can be regulated." The second part of that quote is, I think, apt to what we're going to be talking about now. So while the law may not change the hearts of men, it does change the habits of men, and that's what our ethics laws are about. To the extent habits need to be changed or formed, that's what we're dealing with. And so with that in mind, I'm going to introduce Richard, and Richard will, I'll say, for those of you who don't know Richard, he's coming up. Richard served time, that's a terrible way. Was staff counsel in the Assembly. We all served that time in the Assembly. He was counsel to Bronx Borough President and Attorney General Abrams, who appointed him first Assistant Attorney General, counsel to the Attorney General, first Assistant Counsel to the Attorney General. From my vantage point now, from 94 to 99, he was Executive Director of the State Ethics Commission. He was served under Attorney General Spitzer and Governor Spitzer as special counsel, and he is now special counsel to the New York State Bar Association. And I will tell you that for those of us who do have ethical questions or quandaries or need to bounce ideas off of someone, there is no one better in New York to speak to than Richard. He's truly profound and practical, which is an interesting combination. So with that in mind, I'll give you Richard.
Thank you, Seth. First of all, I brought this with me because my 15-month-old grandchild was visiting me, and she's left me with a souvenir, a cold. So I'm going to try to get through this. First of all, this is an ethics session. And so, as a lawyer, because this is an ethics session, I begin with a disclaimer. And that is that anything I say today represents only my own views. They in no way represent the views of the State Bar Association. So, we're going to discuss ethics this afternoon. And I'm sure all of you read the papers and listen to the public debate. So you're ready to hear about corruption and government dysfunction and drain the swamp. Well, obviously that's not what we're going to talk about because this is a real opportunity to have a serious discussion about the ethical issues, what's going on in ethics, to talk about what we might do. And I must say for that, I can only thank Ross and Seth for putting this all together because we need this kind of discussion. Unfortunately, the public doesn't understand ethical behavior. They've been reading all this. One of these days I expect the next proposal is going to be to reinstate the guillotine and put it up on State Street in Albany and have crowds come out and watch all these people be strung up. That's the attitude the public has of government ethics. And I don't want to minimize it. It's a problem. It's how the public views everyone in government because it tarnishes government. But let's come back and try to see what government ethics are really all about. Now, as Seth mentioned, I spent 30 years in state government. I represented officers and employees when I was with the Attorney General's office. I was the executive director of the first Ethics Commission. And I'm with Seth. And that is, if you look at the state workforce, the workforce as a whole, I am convinced that the overwhelming majority of state workers and I'm talking in areas of 95%, 98%, something in that area, they want to obey the ethics laws. They believe in the ethics laws. Their objective is to obey the ethics laws. And it's hard. I don't want to underestimate the problems in doing that, but it's hard. And Seth mentioned that JCOPE gets all of these inquiries each day. That's what they can really do to help state officers and employees obey the ethics laws. And it's not glamorous, and it's not the stuff you'll read about in newspapers, but it's what they do, and it's their most critical function. So, let's start from the beginning here if we're going to talk about ethics. What are government ethics? What do we mean by government ethics? Well, I submit that fundamentally, government ethics is about officers and employees who are working in the government sector, when working in their government capacity and carrying out decisions in their public responsibilities, that they act in the public interest and not in their own interest. That fundamentally is, to me, what government ethics is all about. And it's hard because state officers and employees have private interests, and they should. They may be business, they may be professional, community, charitable, family, whatever it is. Those are interests that compete with the government work of everyone who is a public employee. And yes, there's a tension there. There's a tension between the public and the private interest. And by the way, this is different from interest in the private sector, because when you work in the private sector, your interest is to, if you will, build the business. And I don't care whether you're the CEO, whether you're on the board of directors or an officer, or whether you work as an employee. If you build the business of the entity for which you're working, you should increase your own wealth. Employees will get raises. People who have equity ownership will increase their equity ownership. And so you don't have the kind of tension in the private sector that you do in the public sector. And that makes it hard on government employees. You always have to make sure you're acting in your public capacity. And that, of course, is when you can go to JCOPE for help. But even that doesn't answer the problems and doesn't deal with the problems that we have today. The reason is we have something called the appearance of a conflict. So if you're a public employee and you make a decision, and you make the decision honestly and fairly and in your public capacity, but in some way you may benefit from that decision. You make a decision with regard to taxes. It reduces, let's assume it reduces everybody's taxes. Well, it reduces your taxes. Therefore, you are personally benefiting. Have you taken that action to benefit yourself? Have you taken that action to benefit the public? You may be absolutely convinced, and you made the decision with only the governmental interest in mind. But how does that look to the outsider? How does that look to the public? How do you convince the public that you didn't protect your own interests? Is this a problem? Take a look at the position Cy Vance is now in. Admittedly, in a slightly different area, it doesn't deal with the issues that are regulated by JCOPE. But here's Cy Vance, Manhattan DA, unopposed. Nobody has ever questioned his integrity. He makes two decisions, which are now out in the papers. One deals with a matter he had on in his plate dealing with Donald Trump Jr. and Ivanka Trump. And it doesn't have to do with what's going on in Washington right now. It has to do with their real property interests. And they're represented by Mark Kasowitz. And he meets with Kasowitz to talk about this. And Kasowitz gives him a very substantial campaign contribution. How does that look to the public in terms of how Cy Vance is acting, even if he's acting totally appropriately? And of course, the big one, and the one that caused this to explode, is the Harvey Weinstein situation, where it's now clear that the New York City Police Department brought some evidence of wrongdoing by Harvey Weinstein to the attention of Cyrus Vance. And he chose not to prosecute the case. Absolutely legitimate decision. Prosecutors have to make that kind of decision every day of the week. But the problem, of course, is that Weinstein's attorney also gave a large contribution to Vance. And now, in this purely appearance problem, Cy Vance has a big problem, other than he has no opponent, so he's not worried about re-election. Vance has raised $350,000 in a race without an opponent, and people are saying, whoa, what was he doing? Well, as you may have read, he has stopped taking political contributions. He has asked an entity from Columbia University to come in and sort of audit what he's done and make recommendations to him. And he basically has said, at the end of the day, I don't expect people to agree with every call we make, but I want them to have faith that we make these calls without fear or favor, based on the merits alone. How does he do that? It's very, very hard. Give you a second example of this, which just came up, and this is almost the other end from a point of view, in my mind, of just being silly, and yet it's a real issue. For those of you who live in the Capital District, you may know a little bit about this. That hasn't gotten a lot of attention. But there was a city court judge in the city of Schenectady who held the bench trial and found the defendant guilty of driving while impaired. That defendant took an appeal, and appeals from the city court go to the county court. In the interim, this judge got elected to county court. For reasons that are hard to understand, he decided to sit on an appeal and hear an appeal from his own ruling. Earlier this week, the New York State Court of Appeals ruled on this. And interestingly, the court found no prohibition on his doing this. They couldn't find a prohibition. But the court said, not only must judges actually be neutral, they must appear as well. Appearance. And based on appearance, they found a lack of due process. So you've now taken the concept of appearance of impropriety, coming back to our issues, and it's been moved into the world of due process. Quite a step. So this is a serious problem, and that's really the point I'm trying to get across. You can't ignore this when you're looking at issues of government ethics. Now, is there any way to just eliminate this, to do away with all these problems? You know, there is. I believe there's a silver bullet. You simply have to impose a requirement that every state officer and employee must live the life of a monk. The only thing you can do after work is go home and tend to your garden. You will have no private interests. JCOPE can go away. Of course, we'll have no officers and employees, But even if we could do that, even if you get officers and employees, I would ask the question, is that what we really want in our public officials? People who are so far removed from the people that they govern. Isn't it a good thing for public officers and employees to have these kinds of private interests, even though they create the kinds of difficulties that we're discussing this afternoon? And by the way, you read the newspaper articles, you listen to the public debate, nobody talks about this. Nobody. Now, what they do talk about, of course, are elected officials and political contributions. And there, I think there really is an identified problem. And that is that I do believe political contributions tilt government decision-making. If nothing else, they buy access to officials. Mainly, of course, we're talking now about mainly elected officials. And that is a problem. But I think it's a soluble problem. And it's solved much more easily than the ones we're talking about this afternoon. And that is, you can put in public financing, you can substantially reduce the amount that you can contribute to a campaign, you can close the LLC loophole. There are real things that can be done in this area. But, I could spend the afternoon on this, but this conference is a JCOPE conference, so we'll stick to the subject of the afternoon. So let's try to give some perspective on this. And Seth certainly began the effort and sort of brought us up to date. My personal involvement goes back to the 1980s. As I think you could, if you went through the sort of the history that Seth was talking about, you realize that the public pays attention to ethics when there's a scandal. No scandal, no ethical concerns. So you need a scandal to generate reform. And in my view, the seminal event in this area was Watergate on the federal level. Resulted in all sorts of major reforms on the federal level. What was our scandal? Well, it wasn't a state scandal, believe it or not. It was a New York City scandal, which was commonly referred to in the 80s as the Parking Violations Bureau scandal. And there may be some of you in this room who recall it. The borough president of Queens, Donald Maness, committed suicide. Stanley Friedman, the county leader of the Bronx, went to jail. Many people think it cost Mayor Koch another term, which he was seeking. It was big, big news. The reason it was called the Parking Violations Bureau scandal, by the way, is it dealt with a contract for these handheld devices, which were then new, that they could use to give parking tickets. And it was the whole contracting mess got in. So how do I become involved in this? I didn't know much about that. I read the newspapers. But I worked for Bob Abrams at the time. I was the first assistant. And Bob calls me into his office and says, we got to do something about this scandal. Was he in a real sort of sense of right and wrong? And I wanted to show Bob my political acumen. And I said, Bob, you really want to do this? Because everybody who's touched this scandal has been tainted one way or the other. And he says, absolutely, we're doing something. So, having gotten instructions from Bob to do something, the question was, what do you do? So we went back and we looked at some of the things that Seth talked about, the ferret hearings, we looked at water, we looked at what the federal government has done, and we came to the conclusion that we had to have an entity of some sort focused on ethics. That was the only way we were going to really deal seriously with this subject at the state level. And we came up with the idea of a commission. And having come up with that idea, then the next question, of course, is, well, if we're going to create a commission, what is it supposed to do? You've got to give it some functions. So again, looking around and seeing what was done, the financial disclosure that Governor Carey had imposed, you figure if you got a commission, it's got to enforce the law, right? So we gave it investigatory and enforcement powers, advice on the law. As Seth mentioned, the ethics laws are not prescriptive. They don't prescribe specific conduct. They're vague. How do we help state officers and employees enforce the law? And you give it the advisory functions, things like formal opinions, informal opinions, telephone calls, and so forth. And education. How do you educate the state workforce? What do you mean by education of the state workforce? Because I don't think anybody can expect more than 200,000 state officers and employees to know all of the aspects of ethics regulation. There are very few who actually know all. And what you have to do, it seems to me, is educate the state workforce sufficiently so that if they're faced with an ethics problem, if an ethics problem arises in their lives, they know enough to say, I had better get advice, and know where to get advice. So if somebody wants to engage in an outside activity, that person should think, oh, ethics issue. I better find out whether I can do it. Or if that person is offered a gift or is invited to a reception of some sort, that person ought to be able to say, oh, that triggers something. I remember that. When JCOPE came to me, they told me about that, and I better check on that. That's what we mean by educating the state workforce. Going back to 1987, once we put our ideas on paper, I was exceedingly pleased. And I say, it's not what would have not happened if it hadn't been that way, that then Governor Mario Cuomo had exactly the same ideas. And he was doing the same thing. And we worked very closely with Governor Cuomo. And little tidbit here, but it shows you, I think, the attention that was being given to ethics at the time. The governor and the attorney general were pressing the legislature to pass this Ethics in Government Act. And early in the 1987 session, they did pass an act. And the governor wrote a memo to the attorney general wrote a memo to the governor urging the governor to veto the bill. And the attorney general, in that memo, put out what he saw as all the deficiencies in the bill. And the governor, to his credit, did veto the bill. The next day, in the New York Times, the attorney general's memo to the governor appeared in full. I have never, ever seen a legislative memo to the governor in any newspaper in this state. But it gives you an idea of the pressures that were being put on the legislature at the time to pass an act. Finally, before the session ended in 1987, they did pass the act and they put into effect the first Ethics Commission. Obviously, over 30 years, there have been a lot of amendments. Seth mentioned some of them. I think there are 3 big ones that I can at least identify. One, the first commission was executive branch only. The legislature took the position that under separation of powers, they could not be regulated by an executive agency. And so we agreed, and the separate legislative ethics commission was set up to do the same thing for the legislature. The makeup of our commission, our first commission, was sort of interesting. It was a 5-member commission as opposed to the current 14-member commission. And it was made up mainly of people who were not from government. We had a banker, we had a retired executive from the Metropolitan Life Insurance Company, we had a minister, and these were not people who were steeped in government. But the theory was that they would impose ethical restraints from outside on government employees. Today, of course, JCOPE is very different. The line between the legislative and executive branch at least has been breached, if not fully, but because the legislature, they now have partial jurisdiction over the legislature, the legislative leaders have been given assignments. And so it's a very, very different commission from the one that we had back in the 80s. And finally, of course, as Seth mentioned, when our commission was set up, there was a separate temporary commission on lobbying. That commission eventually got merged, and now JCOPE has jurisdiction over both lobbying regulation and public officers law regulation. You know, there are things that can be done. We can look ahead. There are a couple of issues. Commission makeup certainly is always one of them, and I don't know which one works better. I really don't have a view on that. One of the things that's always troubled me is our lack of a really reasonable way of judging which gifts an employee can accept and which an employee can't accept. I know there were rules and regulations, and they're like this, and a gift is anything of value, and there are all sorts of exceptions, but I'm not sure the end result really makes sense, and that would be something certainly I would look at. With regard, and maybe we'll talk about this a little this afternoon, with regard to the lifetime bar, can't work on the same case application, proceeding, or transaction. Case application and proceeding, I think, are fairly simple. Transaction is difficult. Moynihan Station, how long has that been around? 25 years? If you worked 25 years ago on some aspect of Moynihan Station, should you now be precluded from working on anything with regard to Moynihan Station? The 2-year bar, based upon relationships, they don't want relationships. Should it apply if somebody who worked in the Manhattan office of the Department of Motor Vehicles wants to appear in the Buffalo office of the Department of Motor Vehicles? Is there a real relationship that should be barred? These are all things that can be examined, although I must say, I'm not sure the time and effort is going to be worth it, because getting legislative changes through is going to be exceedingly difficult. So let me wrap up. Where are we today? Basically, of course, there's all the criticism that's out there. It's serious. I wish it weren't there. And one way or the other, we're going to have to deal with that. Although I must say it does not relate to what we're talking about here. In many cases, it relates to political questions, political contributions. But overall, I think we've come a long, long way in 30 years. Even with the large problems we have today, I would say on a day-to-day basis, and looking at the state's workforce as an entity and in its entirety, I am comfortable that ethics reform has made a real difference. Do we have time for questions? I don't know.
There's a little time for questions. There's a microphone in the aisle, and if some of you are a short comment, this is an opportunity.
Have I exhausted everybody?
Go right to the microphone. Don't wait to be called on. Then if there's 2 or 3, we'll do 2 or 3, and then we'll move on to the next part.
I don't know if I'm going to do the holding of the court justice, but I'm just wondering what you think of what I understand to be the new guidance from the courts that bribes or gifts, let me call them gifts, have the intent of, or is it the impact of actually changing or make a decision, a determination? Do you know what I'm talking about? There are a couple of court cases.
You're talking about
what? Oh, you
Macdonald?
mean the Macdonald case?
Yeah.
Well, the Macdonald case is an interpretation of a federal statute, and obviously they have narrowed the statute significantly, and I think in a way that undercuts the effectiveness of the statute by a long shot. So I can't say in this political environment I'm hopeful But I think Congress really has to go back and take another look at
So much for appearance of impropriety, right?
Yeah, it's a large problem, and I think it allows for the type of conduct that is not healthy to government.
And the honest services, there have been attempts in the state legislature over the last, probably since Skilling anyway, to try to to pass an honest services statute law, and that's gone nowhere. But the legitimate objections to it are that that lifting up the federal statute wholesale creates a certain vagueness in a criminal statute.
Yeah, clearly, if the state were going to do it, we would need a statute that was drafted better than the federal statute, which has created all sorts of issues.
It's a big group. Great opportunity to stand up in front of a lot of people. Okay, well, thank you very much. Thank you for that. But that was a good question, and I hope other people have questions in mind, and we'll ask them. We're going to call up the next panel, and there'll be no break at this time, although you're obviously allowed to leave and come back, but there'll be a break after this first panel. And I want to say that for those of you who are getting CLE credit, we do ask that you fill in the forms and turn them in. Our plan is, as you leave at the end of the program, you'll be able to pick up your certificate right then as you hand back the evaluation. So you hand in the evaluation, get your certificate as you leave. So ask that the panelists on this first panel on investigations come up and take their place. You introduce them? No. Okay, where there's supposed to be more people? Yeah. Okay. You'll introduce them and then just say that. We'll introduce ourselves. Introduce yourselves. And the bios are in here anyway, so you don't have to do that.
You can start. Okay. Hi, we're moving right along. I'm Monica Stammen. I'm the General Counsel at the Joint Commission on Public Ethics, more commonly known as JCOPE. Again, thank you all for coming here today, and hope we're really keeping you awake. So JCOPE, as we've talked about through the history of the law, has basically been around now for about 6 years. It started operations in December of 2011. As Richard Rifkin explained, we have 14 commissioners. The way that we were created, we were given jurisdiction for the first time over both the executive branch and the legislative branch. We share some of that authority with the Legislative Ethics Commission. And we have a commission that's of 14 commissioners, 6 of which are appointed by the governor and 8 of which are appointed by the legislature. They're equally split among the parties. In effect, what has happened is that about half of those commissioners do have state government experience, but half do have primarily private sector experience. So there is a mix of what we get on the table. But there are other compromises that were built into our statute about how they vote and how we operate. But all of the staff's authority comes from the commission. In particular, it does affect how we conduct investigations, which Pepe will talk about when we get to her, when we move along. The 14 commissioners appoint the executive director, Seth Agata. The governor does appoint the chair of the commission. And that is basically how we operate. When you talk about our jurisdiction and authority, the statute that governs JCOPE is Executive Law 94. And as I said, we regulate all ethics and lobbying in New York State. And that also includes municipal lobbying. So we have jurisdiction over lobbying before municipalities, a population of 5,000 or more. And the laws that we enforce, just getting to the practical stuff, is Public Officers Law, Section 73, 73-A, which are the financial disclosure statements that state employees, about 25,000 state employees, including legislature more than 30, file each year. And Public Officers Law, Section 74, which is the Code of Ethics, which both Seth and Richard alluded to, which is sort of the aspirational section of the Public Officers Law. Article 1A of the Legislative Law is the Lobbying Act. And we also enforce the Little Hatch Act, which is in Civil Service Law 107, but that doesn't come up so often. So we have jurisdiction over all state officers and employees in the executive and the legislative branches, and all lobbyists and their clients in the state for the most part. And through that, we have 3 core functions that JCOPE performs. As both Richard and Seth talked about, one of our first and I think our most important function is to help those state officers and employees who want to obey with the law. And so that we can perform that function through guidance and education. And we really actually have attorneys of the day who man the phones. We have a hotline, and we get calls, hundreds and hundreds of calls a year that we answer. We try and respond to everybody within a few weeks. And that is part of our core function. We do regulations. We've got the regulations, which Seth talked about earlier, which are out there right now. We're trying to provide guidance in plain language documents and materials and things like that. Another core function of JCOPE is compliance with the law. And by compliance with the law, I'm talking about ensuring that the people who are supposed to file financial disclosure statements do so. Lobbyists and clients file with us at various periods throughout the year. We get about 40,000 filings from lobbyists and clients, and those filings are all made public. And there's a lot of compliance work administering those filings and making sure they get filed. And we do audits of those filings. But of course, when people fail to comply with the law, that's when enforcement comes in. That is part of our responsibilities and duties too. And I'm going to turn it over to Pepe to talk about how we conduct investigations and, when necessary, assess penalties to take care of when people fail to comply.
Thanks. Good afternoon, everyone. So my name is Pepe. I'm the Director of Investigations and Enforcement at JCOPE. I've been at JCOPE for about 4.5 years. Our unit is actually very small. We have 2 attorneys, including me, and our Deputy Director of Investigations, who's sitting here, Emily Logue. And we have 4 investigators, and we have 2 in Albany, 1 in New York City, and 1 in Buffalo. So we are a very small office, and we do conduct our investigations in-house. I say that because with our city counterpart, the COIB, the New York City Department of Investigations, conducts their investigations. We receive about a little over 200 complaints a year, and we receive them from the public, referrals from other agencies, and JCOPE initiated, self-initiated, based on things that we see. We have a tip line, 1-800-87-ETHICS, and our phone number actually just happened to spell out ethics. And then, and also a website, reportmisconduct.ny.gov. I would probably say that a lot of more substantive cases do come from other agencies, and so we do rely on you guys and a lot of the agencies that are here today to give us information and kind of, forward along any complaints. We also find that in this process, I found that actually a lot of state employees and agencies don't understand what our investigative process is, and it is statutory. So what really happens at the start of investigation, investigative case really starts when we send out a 15-day letter. And that's what we call a 15-day letter. It's a letter that gives the subject notice of the allegations. So I think of it with my litigation background as like a summons with notice or summons in complaint. And the respondent has 15 days to respond. The respondent is not entitled to an attorney, but they are allowed to retain an attorney, so an attorney or the subject can respond themselves. So the respondent has 15 days to respond, and what we do next is we actually present what we call a scope, an investigative plan to our commission to formally open an investigation. So once the commission formally opens an investigation, that gives us actual authority to then investigate a matter. So a commission requires a majority of the commission vote to open an investigation. and we only have subpoena power. So we cannot conduct or execute search warrants, and we cannot wiretap anybody, even though I really want to. So again, this is, my point is we do highly rely on agencies to help us and give us information, and especially because we do, our power is really only limited to subpoena power. And then after the conclusion of the investigation, we will send something called a notice of substantial investigation and hearing. And this document I kind of equate more as like a indictment, laying out all the more charges and the evidence to the respondent. Then we would conduct a hearing if we don't settle. Most of our cases actually do settle, and so we haven't had to conduct a lot of hearings. The law changed recently, so our hearings are now confidential. They used to be public. And after a report and recommendation is released by the independent hearing officer, it gets presented back to the commission again for a decision. They could either adopt the decision, remand for further proceedings, or reverse remand in part, and eventually issue a substantial investigation report. So that's kind of our process in a nutshell. I think when I joined JCOPE, I was thinking I'm going to get all these gift cases, and there would be, you know, lots of bribery, and that really is not the case. So while we do have our gift cases and while we do have our nepotism cases, most of our cases actually really touch upon Public Officers Law, Section 74(3)(d), which is securing unwarranted privileges for yourself or others. So it's there are examples like using state resources to benefit yourself or for your outside activities, which actually we see a lot, using state letterhead, computers for outside activities, you know, using your official position to get people into certain events, just helping friends and families kind of like get hired with the city or state. So that's separate from nepotism because you're getting a family member hired, but you know, a friend of a friend. And so we do see a lot of those issues. On the lobbying end, we actually do see a variety of issues, and we've been, you know, actively looking into failure to files and registered lobbying, and also, you know, gifts. Lobbyists and clients of lobbyists are not allowed to give gifts to public officials. And then on the FDS side, which is obviously part of the Public Officers Law, we've been also really, I think, being really vigilant about going after people who need to file their FDSs and who haven't, and also kind of cultivating cases relating to kind of false filings of FDSs. So that's pretty much a pretty comprehensive kind of the type of cases that we've been really working on recently. I like to say that in the last 4.5 years, we've developed really good relationships with a lot of agencies. I think a lot of you are here because I told you to come. And, but I see a lot of familiar faces, and obviously I'm meeting more and more people from other agencies, and like we really want to reach out and be there. And I've been, you know, everyone on this panel I've worked a lot with, and I see a lot of familiar faces. And we've been developing kind of processes with other agencies, and also would like to welcome more of that, because I think we need to work collaboratively. We've been very helpful with other agencies in resolving matters, because if you go into a matter in the disciplinary sense, like if there is a public officer law violation attached to that, we can come in and we could help. And we've had a joint settlement with SUNY with respect to this. We've worked out with, I think, docs on a matter. So we are here and available to work with you, and we would love to meet and collaborate with a lot more agencies. So please, you know, come by and speak with me or Emily after. If you want to meet with us, we'll definitely do that. And also, like recently, docs came to us and said, we have this particular problem, can you come and do training with us? And then our director of training, who's here, and Emily then, kind of did a specialized training for the agency. And also, I just kind of wanted to remind agencies of the information that we have available for you. Our lobbying forms that are required, our lobbying forms that are lobbyists and clients of lobbyists, that the forms that they need to file are available online on our website. You can ask for people who submit financial disclosure statements, copies of those from us. You could ask Walt McClure, who's here, for that information. And also, please reach out to us, but if you are investigating a matter and you want to get a copy of maybe an outside activity request or maybe an informal decision, we require, and it's a case-by-case basis, a friendly subpoena, and my advice to you would be to reach out to Monica or I and, give us a heads up and let us know, and then we could kind of discuss what you need and what information you need from us. I think my message to the agencies, again, is that we're here and we're here to help and collaborate, so please reach out to us. Second is just be mindful and that, while a lot of agencies in their investigations think about violations of the public officers law, there's also the aspect of the vendors who are lobbyists or clients of the lobbyists that lobby can be giving illegal gifts, and we investigate and enforce that. And also those that appear before agencies that conduct procurement lobbying or lobbying in general who are not registered to lobby, we also enforce and investigate that. And so if you do see that, please, again, just, think of us because we have jurisdiction over them. Thank you.
Hi, my name is Paige Graves. I am one of the people who Pepe said that I had to come, so that's why I'm here. I am the general counsel for MTA Bus Company, as well as the ethics officer for MTA Bus Company and New York City Transit Authority. Both MTA Bus Company and New York City Transit Authority are, technically New York City Transit Authority is an affiliate of the MTA. MTA Bus Company is a subsidiary of the MTA, but we are a public benefit corporation, very small benefit corporation. We only have 70,000 employees under the MTA family, included under the MTA family is MTA Capital Construction, Bridges and Tunnels, Metro North, and Long Island Railroad. And I have to shout out to my colleagues who are here from the MTA. Thank you for coming. I was also going to mention a little bit about my background, but then when the example of the Manhattan DA's office came up, I thought, ooh, maybe I shouldn't tell them I'm a former prosecutor from the Manhattan DA's office. But I am. That's how I started my legal career, was as a prosecutor with the Manhattan DA's office. I mention that because I also want to shout out to my former colleagues from the Manhattan DA's office, which includes Nelson, who's sitting next to me, who I have not seen since we left the DA's office many, many years ago. So it's really nice to be on the panel with him. So I mention my background as a prosecutor specifically because it's relevant to what I do as an ethics officer. I think that training helped me with my investigative skills and assisting the investigative group that investigates primarily the ethics-related issues that come up within the New York City Transit and MTA Bus Company. So as an ethics officer, my role is to provide ethical advice to management and to our employees, to help with the other agencies' ethics officer. I should add that each of the agencies that I mentioned have their own ethics officer. So when I get a phone call from an employee from Long Island Railroad, I can happily say, no, I'm not dealing with that issue. You have an agent, your ethics officer is so-and-so. So I only deal with just the New York City Transit's ethics issues, which keep me quite busy. We also, all the agency's ethics officers work very closely with our chief MTA's Chief Compliance Officer, who is pretty much in charge of maintaining good corporate governance and the compliance within the MTA. We work with him to establish all agency policies, as well as periodically review our code of ethics to ensure that it's up to date and we're covering many of the issues that we see come up. Our code of ethics mirror a lot of what JCOPE and the Public Officers Law outlines, so that we're in compliance and in step with what JCOPE asks us to do and state employees. I guess, as the ethics officer for New York City Transit, most of you may think that I have a huge staff. No, I don't. It's me. But I do have an amazing investigative department. Unfortunately, that investigative department just doesn't investigate ethics issues. They investigate many other issues. I work very closely with them, and they work very closely with an outside agency that's an oversight for the MTA, which is the MTA Inspector General's Office. I also give a shout out to them because many of those employees are here as well. So we work very closely with the IG's office. They provide a huge resource for us where we get cases that is really beyond our scope to handle. The IG's office will provide us the resources and in many cases take the case from us to investigate. We do joint investigations with the IG's office. The IG's office has subpoena power, which helps because, as Pepe mentioned, when we need to get, let's say, financial disclosure statements from JCOPE, IG's office typically will do that for us. So our investigative process, it's pretty much, I guess, like any of your investigative groups within your own agencies. We will normally receive a complaint. Primarily our complaints, I would say about 83% of the complaints or inquiries that we receive is by email. We do have a hotline, and believe it or not, about 7 or 8% of the issues that come to us are through our hotline. You would think that a lot of people would want to be anonymous when they're complaining or I guess, for lack of a better word, ratting out their fellow employees, but they don't. We actually reported to the MTA board in June with some interesting statistics, and one of those statistics is about only 22 individuals really request anonymity, I can't pronounce the word, wanting to be anonymous. And that's surprising for an agency or agencies as large as the MTA. Through most of the complaints that we receive really involve outside activity, some nepotism, but vast majority of the issues that we handle really are inquiries, and I'm just to test to see if you all are still awake. What do you think the #1 inquiry is that we receive? #1 question that we get. And we usually get that question around March or April. Financial disclosure. Thank you. Financial disclosure. So vast majority of our inquiries pertain to financial disclosure. And I guess the second #1 inquiry would be outside activity. So another interesting fact, we as an overall MTA, the 70,000 employees, we only get about a little over 2,000 matters, and as I said, the vast majority of them are just inquiries. That's like about 1,900. So out of all of the agencies, we only really investigate about 100 complaints that pertain to other matters, ethic-related matters. Most of the cases usually involve something other than ethics, and then the ethical issue arises as the investigation goes forward. I'll just highlight one or two cases that we dealt with, and I dealt with PayPay on. One case was a sexual harassment case, and the employee, female employee, went to our Office of Equal Employment Opportunity, so that's another group that I deal with very closely, complained about her supervisor harassing her, sending her emails and pictures, very inappropriate emails and pictures. The complainant then proceeded to say that not only is he sending me all of these nasty pictures, but he has me, completing invoices for his outside businesses. So then she decided she's going to file a lawsuit. So now we have various different groups involved. So you have the legal department dealing with the litigation. You have EEO dealing with the actual the complaint of sexual harassment, which once she filed, as you know, once she filed the litigation, the EEO sort of stepped back. And then you had the allegation of outside activity, her doing work for his outside activity, and that's where I got involved. So our investigative group investigated, pulled documents, the emails, the pictures, and while the litigation went in one direction, the outside activity investigation went in another direction, and that's where we contacted actually the MTA IG's office. Typically our cases our referrals to JCOPE usually are through the IG's office. And then JCOPE stepped in and assisted with the investigation for the outside activity. So that's just one example of where we work very closely with not only the IG's office, but also JCOPE. We conduct a lot of training for our employees, and that's primarily why I think the number of complaints are not as high as you would expect. They annually have to complete ethics training. Once a month, every month, we post information on our intranet informing our employees of different ethical issues. When I joined MTA Bus Company, which was almost 2 years ago, I actually went out to all of the depots within MTA Bus Company and actually did my own training, so live training, which I thought was very important to do. So we take seriously training as well as posting information, the hotline, and just getting our names out there so that way people can report things. I think it's important, training is important to not only help deter bad activity, but it also helps our employees understand what to look for and who to go when something arises. I would say, I guess a takeaway to give to you would be that you should work very closely with any oversight agency that you're dealing with. You should not be afraid to work with your oversight agency. We have a great relationship with the IG's office. I know I personally can pick up the phone and call anyone there with a question, and I know I will get an answer. I work very closely with JCOPE, and I have a great relationship with JCOPE, which is important. It makes our lives a lot easier. So that's my takeaway. I'll pass it on.
Thank you. Nelson.
Thank you. I'm Nelson Scheingold. I'm Deputy Controller and Counsel for Investigations for the State Controller's Office. You know, I love these events. I see so many people I haven't seen so long. And I said, Paige and I saw outside. We were in the Manhattan DA's office together. It's probably been, should I admit how long?
Go ahead.
Okay, at least 15 years since we've seen each other. So we had one of those. You know, outside. Wow, when did we become the grown-ups moment?
Right.
But it's, you know, it's great being here, and because this topic is so important, and it's so important for all of us and what we do. And you know, when Pepe had originally, you know, asked me would I be interested, you know, in doing this and talking about ethics and corruption investigations, how they relate, the first thing I thought about was back in the last job when Phil and I worked together at the Inspector General's office. We had done this big report on an agency which remained nameless, and we ripped the living heck out of it. It was a long report. Their policies were messed up. You know, people are taking advantage of different things. There's loose controls. You know, everybody has these sinecure positions. You just ripped into it, but there was no crime. Well, it made the press, and there's an interview with the head of the agency, who naturally does, and we've all seen this before. I told you I didn't commit a crime. And they interviewed our old boss, Judge Fish, and he looks, and I wish I could deliver like him. He goes, yes, but mere lack of criminal conduct is not the standard we're supposed to hold our public officials to. I mean, for those of us who have read the Macdonald decision, and I hope, I mean, it's basically everybody at least read about it. Just pretend you have. But, I mean, if you read that decision and what he did, nobody who reads the conduct, whether a criminal or not, is going, hey, boy, where can I vote for this guy? You know, www.friendsofbob.com. I mean, you're not hitting it because people do expect us to act a certain way, whether it's criminal or not. So I want to talk a little bit now. I want to talk a little bit about what we do at the Comptroller's Office to investigate corruption and expose ethics and hopefully try to prevent ethics violations working with our friends and other agencies. And I want to talk a little bit about the intersection between doing corruption investigations and ethics investigations. So to understand how we at the Comptroller's Office and Division of Investigations investigate these matters, first you got to sit back and just look at the breadth of the authority of the Comptroller's Office. And I've been in state government for over 20 years, you know, when I started, I've been here about 7 years, and I got to tell you, I still didn't realize just the vast amount of authority and the duties that are placed on the state comptroller. So just to give you a little flavor, as everybody knows, the comptroller is the independently elected constitutional watchdog of New York State finances. And in that, there's various aspects that the Comptroller's Office touch. I'm looking down, I pulled some stats just to give you some flavor, because you got to really realize the breadth of it. So under the state constitution, no state money can be paid that doesn't go through and is audited and pre-audited by the Office of the State Comptroller. Last year alone, that was, let me get you the number for you, $31.6 million in payments, million payments worth over $130 billion. Okay, by the way, if you're curious, we already rejected payments worth $8.5 million that we didn't think were up to snuff or somehow otherwise invalid. We also, under state law, have to approve contracts over a certain amount in certain categories. Last year alone, the Comptroller's Office reviewed over 19,000 contracts and approved them worth over 50, make sure I got this, $billion. I always feel like Dr. Evil when I say that. So, and that's just on the payment and contract end. And in addition to that, the state comptroller is a sole fiduciary of the state retirement system, which is really important to me because if it goes south, my mom's going to move into me and I can't afford the divorce from her. But anyway, the state retirement system alone has 1 million members, pensioners, and beneficiaries attached, and I assume virtually everyone, if not most of the people in this room are not in the city system. It's also worth over $190 billion that's managed by the Comptroller's Office. In addition to that, the Office of the State Comptroller also runs the state's Office of Unclaimed Funds, which hopefully everybody's run their name. You never know, it's something a lottery guy. And that alone, we pay out $1 million a day to people seeking who have funds that have been escheated to the state that we hold in their name, waiting for them to claim it. On top of that, under the state constitution and state law, the Comptroller's Office audits local governments across New York State, the thousands of different government municipalities, special districts, sewer districts, fire companies, fire departments, fire districts, across the breadth of New York State. And we conduct well over 300, sometimes close to 400 audits of those companies a year. In addition to that, the state controller also is, of course, the auditor for all the state agencies and city agencies, and we conduct performance audits of all these agencies. So we have this vast authority to safeguard public finances and to try to set the standards which public officers should hold themselves to and set controls to prevent fraud. Well, then the question becomes, well, what happens if that doesn't work? What happens if during course something slips through the cracks? What happens if during course we find that somebody had violated these standards or otherwise? Well, Comptroller DiNapoli decided that we hadn't fully harnessed our ability in the State Controller's Office to use our authority to investigate these matters. So we created the initiative that led to the Division of Investigations, which I currently head. And we use all the office authority in all those areas I just spoke about to look. And if somebody has transgressed these various prescriptions, obviously they're all different in all those areas, then to investigate it using all our tools at our disposal and to work with our friends in law enforcement to bring the people to justice and hopefully to get people their money back, to get the taxpayers their money back, because at the end of the day, we are the State Controller's Office. And to get the end, I'll get a little more specific. Over the last 6 years, our efforts have led to 158 arrests and over $50 million in audit recovery. So you can see there's a lot out there, and there's a lot to do, and it's been, highly, highly successful. Now, how do we do this? Well, we do that, once again, both sides of the coin. Like I said, when we go in an audit, if we're out there, we're doing it to try to set the standards, to look at the internal controls of these various entities that we're looking at. So the hope is, like Richard was speaking about, and Seth was speaking about, hopefully you set controls, you set standards, and the people, and the vast majority of people who work in these public entities who want to do the right thing are going to do the right thing and going to be educated and follow procedures. But we're also looking to set things up that the people who aren't going to do the right things, those people you can't dissuade, the people who are going to take advantage of their position, first of all, that we make it hard for them to do it, and second of all, if they do it, that we can prove it and they'll get caught. Because if you have no controls, and I'll use a couple of examples in a few minutes, it makes it very, very, very difficult to prove a case, particularly a criminal case. Then on the back end, like I said, if we go into any of these entities or we're looking at any complaints that come in, and I'll talk about our complaint system in a minute, we're going to investigate it, and we're going to figure out how it happened, what happened, how much, and who we can work with, be it criminal, be it with the relevant ethics authority, or otherwise. And these preventative aspects we're all talking about and the investigative aspects really work together. It's cyclical. Because what's going to happen if you have bad controls, if you don't educate your people, if you don't have standards, if you don't have various mechanisms and checks and balances in place and people violate it, it's going to turn into an investigation that we do. Then again, at that point, things have already gone south. Hopefully by educating not only that department, telling them how this person was able to get away with it, we're not only preventing future crimes there, misconduct there, but we're also educating the public at large that this can happen to you. So let me give a good example on the local level because it's a little easier. We did an investigation last year of a fire department in Mahopac, New York. And this one actually didn't come out of an audit. It came in a referral we had from law enforcement saying, hey, it looks like there's embezzlement here, maybe millions of dollars missing. At the end of the day, we went in, worked with the state police, the FBI, and U.S. Attorney's Office. The treasurer of the Mahopac Fire Department had embezzled $6 million over the course of 10 years. So you sit back. My first thought is, wow, they have $6 million to steal. But once I got over that shock, and is he some master criminal? Did he set up some phony company? Did he bring people in? No. He was a treasurer. Nobody was watching what he was doing. He actually had a machine in his personal business where he could cut checks for the fire department right while he was sitting at his desk in his personal business. these checks he was making out to himself, to two of the businesses he owned, one named after his daughter. Took all our investigative skill there to figure that out. But we're talking $80,000, $100,000 at a pop. Then he was going into the books and records of the fire department. That same check 101, which he's writing to himself, he's putting there, Nelson's Fire Hose Company. If somebody would have just taken the ledger and taken one check, it would have been exposed. So the bottom line is he now resides in, I think, Allenwood Federal Penitentiary. The odds of us getting the $6 million back from him are pretty nil, but we're trying our best. We took the yacht he bought, by the way. But in the wake of that, needless to say, we suddenly had lots of fire departments, when this got publicized, looking at their own procedures. And in fact, right after the story broke, about 3 weeks later, we got a call from another fire department right down the road at Patterson, New York. Hey, can you come in? We think we got the same problem. Their treasurer only stole $1 million. So these work hand in hand, the preventative aspect and the education aspect, and they have to inform each other as you go along, because otherwise it's going to be Groundhog Day, and the numbers are just going to rise, and we're going to keep repeating things. So where do our cases come from? I already mentioned the audits we do of all these various aspects of the controller's authority. We also run a fraud hotline and actually a website, and we get many more complaints coming in the website. We get about 3,000 complaints that come in a year, and that's just what comes into Division of Investigations. We get many more that come to the local audit shop and state audit shop and the like. So we do get a lot. Some are anonymous, and those of us who have done cases with anonymous complainants, it's difficult because obviously you can't get the necessary information a lot of the times. But that being said, I think those of us who do this have all made cases out of those anonymous complaints. So you have to, once again, pick and choose what you do with those. We also, as I mentioned with the mail pack case, get lots of referrals from law enforcement seeking our expertise in dealing with the workings of state government and local governments, and also to ask for some of our forensic abilities and our specialty in the area. One of the things hopefully I'm not talking, okay, I'm good. But one of the things I want to just talk about also in general is, especially in the wake of Macdonald, I do want to talk about in all seriousness for a second, there's going to be even more of an onus on basically for us to take care of our own. And even in the Macdonald decision, if you go back and read it, and it's a very narrowly written decision, they clearly, although there's a paragraph on it, didn't want to reach the due process issue any more than they had to. So like Richard said, they kept it as much as they could confined to the terms of that federal statute. But if you keep reading down, there's a part in there about federalism concerns, saying it's up to the state to set the relationship between its public officers and its public employees. So now that, depending how you look at it, either the nightmare or the halcyon days of the honest services broad reading are over, there's going to be much more look at us to be policing these actions, both criminally and, if not criminally, as ethics matters and civil matters. And once again, these work together for, I don't have time really to go into depth into this, but if you go back and you look at some of the statutes we already have on the book, official misconduct, receiving a reward for official misconduct, bribery statutes, coercion, which is a great statute that's underutilized, they all talk about violating a public officer's duty. There's case law, ample, New York case law out there that local ethics laws, the judiciary code of ethics, and the public officers law can serve as a predicate for that duty. And if anybody's curious, just grab me later. I can give you some of the sites. So when you're going in to do this, if you're going to do a public corruption investigation, you need to know what rules apply. Because even if it either is going to turn criminal and you're going to be using that to understand the crime, but if not, going back, the public gets more from people just not to commit grand larceny. And that's where we need to act on it from there. So I don't want to go off on a complete Macdonald rant, but anybody grabs me later, believe me, I will. But once again, these are things that are very much in the public focus right now, And we're the ones charged with now taking care of it, both in our own behavior, how we set the standards, how we train people, but also what we do when those transgressions occur. So I would encourage anyone, if you do find some sort of issue, do report it to us. We do play nice in the sandbox, and I've worked with a lot of you in here. And working jointly, we can try to rid this.
Good afternoon. I'm Phil Foley. I'm the Special Deputy Inspector General, and I run the downstate region of the Inspector General's office. The Inspector General is Kathy Leahy Scott. And I'm here because Monica made me be here. Seth, I'm going to speak to you about that later. I was threatened. She made me be here. But there's a certain amount of inbreeding with corruption fighters, and Nelson, of course, was in the Inspector General's office, was our chief counsel. Monica was the chief of staff. And Richard mentioned before the Parking Violations Bureau scandal that ended in the conviction of Stanley Friedman, and I was involved in that prosecution at the U.S. Attorney's Office. And of course, there was much more than just that. We also indicted and convicted two Bronx congressmen, Congressman Biaggi, Congressman Garcia, and the borough president of the Bronx, Stanley Simon, at the time. And that was almost 25 years ago, and I remember feeling elated at the time, saying, wow, we're really making a statement about public corruption, and this is going to be a real deterrent effect on this entire process. And here we are 25 years later with all of our political leaders under indictment and escaping maybe because of Macdonald. So it's vitally important that we stay vigilant about corruption because obviously it just goes on and on. Our office has expanded mightily since you guys were with us. We have responsibility not only for all state employees in New York State, all boards and commissions where the chair of that board or commission or authority is appointed by the governor. As was mentioned, there's over 200,000 state employees. Anybody doing business with the state falls under our jurisdiction. Our jurisdiction has recently, and our office has been broadened. We now do welfare investigations. We're the welfare inspector general, and Jessica Silver is somewhere in the back, and she runs our welfare investigations for the entire state. We also now have the workers' compensation inspector general under our umbrella. And if that's not enough, we were given responsibility for the Mario Cuomo Bridge and that construction project. We now oversee, and Jessica Silva once again does this, the Javits Center and the Moynihan Center is all part of our responsibility and oversight. And the amazing thing about those projects to me, when we began to get involved, we met with the feds and they said, you know, you really have to set aside maybe 1% or 1.25% of whatever budget there is for fraud protection. And the example that they gave us, when they did the big dig in Boston, which was a $20 billion project, they estimated that as much as $5 billion was misappropriated due to fraud. When we talk to people who are running these projects, and the bridge, for instance, is a $4 to $5 billion project, by the way, did you set aside 1% for fraud prevention? And it's were we supposed to do that? And we see that in every single project. I think there's a greater enlightenment about setting aside money for fraud prevention because it saves money in the long run. Our office obviously runs throughout the state. Again, we have more offices than we did when you guys were here. We have an office in Hauppauge, in Suffern, and not to mention, of course, New York City, where I am, Albany, Syracuse, and Buffalo. So we are all over the place. How do we get our authority? Through Section 4A of the executive law, which gives us the authority over all state employees. And one of the great investigative tools that we have is that we have administrative subpoena power and the ability to call in state employees without subpoena and, if necessary, compel them to speak to us under the threat of loss of their job. We don't do that very often. We try to avoid that, but we have that power. In terms of ethical concerns, we always are concerned about having public employees come in and speak to us, particularly if we think that their conduct was criminal. Garrity, of course, you know, is a protection. It's basically the Miranda version for state employees. So if we think that something is going criminal, we will contact one of our prosecutorial partners and work through them. I will tell you that our responsibility runs the gamut. Recently, most of our focus has been on cases that are going to go criminal, and not necessarily the old time abuse cases and people taking advantages of state resources, et cetera. But I did want to talk a little bit about how sometimes we wonder, how is something that's not criminal, there's some malfeasance or some inappropriate behavior or conflict of interest, what kind of impact does that really have? And sometimes you think, well, it's not a big deal in the scheme of things. It's not criminal activity. We did an investigation of the State Athletic Commission, and they assign inspectors to fighters before fights, and those inspectors are to stay with the fighter from the moment he arrives at the arena till he leaves, to make sure everything, one, is kosher, but also to protect the health of the fighter after the fight. And they're not paid very well, but there are very strict ethical constraints upon them. They're not supposed to get autographs from the fighters. They're not supposed to take pictures with the fighters. They're just supposed to be there to do their job. Well, about 2 years ago at Madison Square Garden, there was a heavyweight championship fight, and the heavyweight champion of Russia was a man by the name of Magomed Abdusalamov, who was a very highly respected fighter. The inspector who was assigned to him was an autographed hound, so to speak. There was an even more significant fight that was going to happen after the fight that he was involved in, involved with a guy named Golovkin, which I think is a big name in boxing these days. And he was intent on getting his autograph and to get the wraps from his hands that he could auction off. Abdusalamov was in a very brutal fight. It turned out he was seriously injured. And when the fight was over, no one realized the extent of his injuries with the post-fight inspection by doctors, except for the inspector, who had to stay with him while he took a urine sample, for instance, and to see if he had any complaints. Well, guess what? There was blood in his urine, he was feeling dizzy and had headaches, and asked to go to the hospital. The inspector was so intent on going to the next locker room to get the autograph, he told, and when the inquiry was made, how do I get to the hospital? He said, why don't you go outside and take a cab? Now, there are 2 ambulances that are assigned for this purpose, 2, and they were outside the hospital, outside the arena. Magomed went outside the arena and collapsed. His handlers then put him in a cab, which we got videotaped because, unbeknownst to me, there are 2,000 cameras at Madison Square Garden. You should know this. There is no place at Madison Square Garden where you are not on camera, except the men's and ladies' rooms. They have everywhere. So it made our case great. But we see him collapse outside, and then his handlers get him into a taxi cab, which the taxi cab was right next to an ambulance that he could have been in. Make a long story short, he was brain damaged, barely survived. He was in a vegetative state for a while. He currently is recuperating. He has no speech. He can't walk. And this is all because this inspector didn't pay attention to his job and to tell him what he should do next, so to speak. And he just left him there, all to get an autograph. So it has tragic results when you have these lapses in judgment. We had another case involving scrap metal in the state of New York, where you say, well, scrap metal, what does the state do with that? Well, it has a certain value. But we saw some people that were operating in New York City, they were taking the scrap metal for their own purpose. And that's fine, that's a criminal act. They stole the scrap metal, they brought it. Once they were finished with the supply that they had, however, they decided to get a new supply of scrap metal, and they started dismantling a bridge, literally the guardrails on the bridge going into Roosevelt Island. This is a serious matter, clearly. They dismantled half of the guardrails going in. So these are the type of things that are sort of maybe perceived initially to be small matters that are very serious. Another example that I can give you is at City University, which we've been investigating intently over the last couple of months, and I won't tell you where or who the people are yet. One of the professors was running his own class out of the City University for phlebotomy. Is everybody familiar with that? It's the drawing of blood. And by the way, you'd be interested to note there is no certification requirement in New York State for phlebotomist, which is mind-boggling to me. So you don't need a certificate, you don't need any kind of license, but nevertheless, that's the case. This particular professor was undercutting his own college by giving a class cheaper than what the university did. But we also discovered by sending undercovers in that he's willing to sell the certificates to people, and we bought a couple. So next time you go to give blood, be very wary of who's drawing your blood. I'm told to wrap it up, so I will. Again, that's Monica. She's tough.
It wasn't me, it was her.
Just quickly, we have a hotline. We have a website. We take investigations from wherever they come. We read the newspapers and find outrageous things, and we follow up on them. And we encourage state employees to contact us if they perceive there's a problem. So I'll be around later for any questions as well. Thank you.
Let me thank the panelists, and we're going to take a 10-minute break, and then we'll begin exactly at 4 o'clock. And I'll ask the panelists for the next panel to come on up so that we can begin on time.
I've been assigned to oversee you. You know, Cougar is such a low.
As we know.
No, I mean, I don't have to give you any preface. I'm not going to say to me, why do you say that? Exactly. So I just thought I'd bring it every day. There's no more saying before. I went to a meeting with him today.
Really?
Yeah, but it's still, I love my life. You obviously love it.
Keep doing it for a while.
I know. Nelson.
That one was, I feel like that.
Nelson's a character. I love this.
Nelson, what I got here.
Oh, yeah.
Mike got So Mike told me, call Nelson. Nelson puts his resources so generous. With his knowledge.
He's a smart guy. He's a
Very, very, very smart. Yes. We have some of that.
Yes.
I don't try to call it. But this is good. You know, this is good stuff. Plus it goes to
I think this gentleman's running the mics.
Sure. One? Okay. And don't move the placement of it, that looks like you're saying?
Yeah, the closer the microphone is to you, the better I can.
Okay.
Okay.
Will you give us like a signal that you can't hear us?
I'm sure a lot of people.
I'll use my stage.
I'm going to be first.
You'll have to adjust it back.
We should introduce ourselves as we go along.
We need to cut into time. It can be mine, since mine's the least relevant to everyone in this room.
And then it's supposed to be 10 minutes for questions if there are any.
Clock to watch how we're doing. Oh, there's. I'm looking for a clock so I can see how long we've spoken.
No. Well, I know your number by heart. And I don't. Yeah.
Mm-hmm.
Oh, I'll sit down.
Okay.
How'd you find me? You asked somebody?
Sitting works, yeah, then we won't have to
You're a detective. All right.
You know, he said don't move it, but I'm moving.
Okay. And we're in the Smith building across from the Capitol.
and so muscle relaxants and painkiller. And so I find myself. Oh, yeah.
I know when I was studying for law before 10 years, I was doing it up in Ithaca, so it was on video.
Okay.
And I had to,
You're at an agency now?
I had to
I am with
and it was such a struggle.
I was
Yeah.
trying to just
Yeah.
Okay.
agriculture and markets, but a brief stint at DEC.
I'd all of a sudden I'd wake up and I'd look around to see who's like looking at me.
Right. Sign out.
Okay, okay. You hear from Anthony? If you take your seats, we will begin in just a few seconds.
It's, I mean, it requires.
Time.
Sure.
Right.
But still, you have to humor me, you know. Right.
How are you? How many people do you know?
Oh, all of JCOPE, because I actually briefly worked there. Yeah, yep. I went over to do like some training stuff, and then I wound up going back to the LCC. I love everyone there. They're all great groups.
Yeah.
I actually, it's interesting.
Okay.
My son's name is Folio. He did.
We're going to begin the second panel. We're going to begin the second panel on post-employment.
I'm on a daily basis on the phone.
May I ask that you take your seats? Order in the court. Will the chambers please come to order? Okay. They said this was a good networking opportunity. I'm sorry to bring it to a close because we are going to go on to the next panel on post-employment. Let me remind you again, though, at the end, those of you who are earning CLE credits, we ask that you fill in the evaluation form and turn it in at the tables right here in the gallery, right outside this room, where at the tables, and at those tables are the CLE certificates which you have earned by your close attention to this seminar. So we will now begin the next panel on post-employment.
Good afternoon, everybody. My name is Michael Sand. I'm the Deputy Director of Advice and Guidance at JCOPE, and I'll be providing a kind of nutshell version of the post-employment restrictions today. Of all the statutes JCOPE enforces, the post-employment restrictions probably affect the greatest number of state employees. In 2016, JCOPE issued approximately 170 detailed written responses to inquiries regarding the post-employment restrictions, and several times that number of telephone calls regarding the post-employment restrictions. It's a constant subject that comes up every day. The first question that often comes up from people who call is, why do we have these rules? They're so unfair. And they do often have some harsh consequences, but they do have a purpose. And in reviewing the many advisory opinions that we have issued and our predecessor agencies have issued, I've identified about 3 reasons or purposes behind the post-employment restrictions. One is to prevent former state employees from using or leveraging the knowledge and experience that they gained from state service to benefit themselves or others after they leave state service. And that's as opposed to someone who never enjoyed the privilege of serving the state and didn't have the opportunity to gain that knowledge and experience. Another purpose is to prevent former state employees from receiving special treatment or creating the appearance that they may be receiving special treatment while engaging with their former colleagues. And a third reason is to reassure the public that when state employees are making decisions, they're doing so in the interest of the state and not to kind of set something up for themselves after they leave state service. Like here, I'll grant a contract to this ABC company and then I'll get a job with ABC company after I leave the state. So the rules are on the books and they do have a purpose. And so how should we deal with them? Well, our first line of defense, as a number of people have mentioned, is advice and guidance. Right? We have a very strong preference for providing guidance prospectively as opposed to investigating a possible violation after the fact. So we do a number of things to educate. We provide agencies with leaflets to post in common areas. We send out ethics reminders to ethics officers. We publish a quarterly newsletter. We answer inquiries, as I mentioned. And we are also trying to work with GOER to provide prospective state employees with specific information regarding the post-employment restrictions so they're not surprised by it later. I mean, everyone does receive, or at least is supposed to receive, a copy of the public officers law when they get hired, but not everyone takes note of the post-employment restrictions at that time. The post-employment restrictions in the public officers law apply to just about everyone who receives a salary from the state. That's a generally true statement. And that ranges from the statewide electeds to heads of state agencies to clerical staff and everybody in between. They're all subject to the post-employment restrictions. They don't apply to the judicial branch. There are separate provisions for legislators and legislative employees, and I'll defer to Kate to discuss those later. So the first post-employment restriction, the 2-year bar, it has 2 clauses. The first clause we call the appearance and practice clause. So this prevents or prohibits a former state employee for 2 years after they leave state service from appearing or practicing before their former agency. Now, an appearance or practice can have 2 general forms. It can be direct communication with a former agency, or it can also take the form of submitting documentation that contains identifying information. So like a personal appearance would be something like negotiating a contract with one's former agency, representing a client in an audit before one's former agency, calling one's former agency on someone else's behalf, or seeking information from your former agency that isn't available to the public. Those would all be violations of the appearance and practice clause. They are actual appearances. You can also violate the appearance practice clause by submitting documentation that has your name on it. The key there is that the former employee is identified in the document, and that's the appearance. The second clause is called the backroom services clause. And this kind of applies behind the scenes. It prohibits a former state employee from providing services on a case, proceeding, application, or other matter that is before one's former agency. And crucially, with respect to the backroom services clause, is that the former agency need not know that the person is working on the matter, right? So this would prevent someone from helping someone to prepare documentation that they reasonably anticipate will go to their former agency, even if their name doesn't appear anywhere in the document. It could also cover advising someone else how to handle a matter that's before your former agency. Even something as simple as telling somebody who to call at your former agency could be a violation of the backroom services clause if it relates to a specific case, proceeding, application, or matter that's pending before your former agency. So this raises 2 very important distinctions or nuances that I think often get overlooked between backroom services and appearance practice. The appearance practice clause is a flat prohibition. The activity is prohibited under any circumstances. The prohibition on backroom services is a little narrower. First, it only applies with respect to a specific case, proceeding, application, or other matter. So there has to be a related matter with respect to the services that you're providing. And the second distinction is that the actual prohibition on backroom services is on the receipt of compensation, right? You're prohibited from receiving compensation, from being paid for providing backroom services. So you can do backroom services for free on a volunteer basis, and this would permit someone to, say, help a friend for free, prepare documents that will be submitted to one's former agency. That would not violate the 2-year bar. It's not common, but an individual can have more than one agency, former agency, for 2-year bar purposes. This usually results when an agency assigns one of its employees to perform services for another agency. So say agency A says, we're assigning you to assist Agency B with their ABC project. And then you go over to that other agency and you are now working on that other agency's project. If that rises to the level of continuing services, the provision of continuing services to that other agency, you may be deemed a former employee of both agencies. You're officially employing agency and the agency that you're providing services to. And that's an important thing to keep in mind whenever an agency assigns an employee to work with any other agency. There's also the lifetime bar, which of course applies for the lifetime of the state employee. It prohibits a former state employee from providing services relating to a case, proceeding, application, or transaction that they worked on as a state employee. There's a little nuance here. The matter referred to in the 2-year bar, well, the 2-year bar refers to case, proceeding, application, or other matter. The other matter phrase doesn't appear in the lifetime bar. In the lifetime bar, the other matter is replaced by transaction. And I mean, it's not perfectly clear what the distinction is, I think, but transaction winds up covering maybe the majority of issues that come before us when we're dealing with the lifetime bar. If the services are performed before a state agency, the prohibition applies regardless of whether you're paid or not. You simply can't provide services before a state agency on a matter that you worked on while you were with the state. If the services are being performed before any other entity, again, you can do it for free. Now, the involvement with the prior matter has to be more than a passing acquaintance or tangential involvement. Sitting through a single meeting regarding a particular matter is probably not enough to trigger the lifetime bar. According to the statute, it must rise to the level of direct concern and personal participation or active consideration. So there is a certain bar that has to be met by the level of participation. So some examples of the application of the lifetime bar would be, say an employee participated in a review of the computer systems of his or her agency. After leaving state service, he would be prohibited from participating in the sales of computers to his agency that arise out of the review that he participated in. A former employee cannot help to prepare a response to a request for proposal if he participated in drafting that request for proposal. And I think, as was referenced earlier, generally in the context of a construction project, a person cannot leave state service and then go back to work on the same project as a private sector employee. So the two basic questions to be addressed in the context of the lifetime bar are, is it the same case, proceeding, application, or transaction, and did the prior involvement rise to the statutory level that triggers the bar? The executive chamber has a special provision, and former employees of the executive chamber are prohibited from appearing or practicing before any state agency. The chamber and any other state agency for 2 years after they leave state service. Backroom services for compensation are prohibited, but backroom services before the chamber are prohibited, but backroom services before any other state agency are permitted, regardless of whether you're getting paid for it. And the lifetime bar applies, as usual, to former employees of the executive chamber. An important exception to the post-employment restrictions is what we call the government-to-government exception. If someone leaves state service and then accepts another job with another governmental entity, whether it be a federal, state, or municipal agency, the post-employment restrictions won't apply if that person is acting in their capacity as an official of that governmental agency. I mean, this encourages government service and basically facilitates government work. And I think I'm going to let Ruth discuss that a little bit more. And right now I'm going to turn things over to Jim.
Great. Hi, good afternoon. My name is Jim Deering. I'm a partner at a law firm by the name of Garfunkel Wild. It's a law firm that focuses on providing services to healthcare providers. And you're probably wondering, well, why is Jim here? Prior to my present position, I was the general counsel at the New York State Health Department. So I have some perspective with regard to the post-employment restrictions, not only in that capacity, but also personally in terms of my switch from state government to the private sector. And then as an aside, in June, I happened to be appointed by the governor as a commissioner to JCOPE as well, which is a real pleasure. In preparing for today, I wanted to come up with some anecdotes in terms of situations that happened when I was at the health department to give a couple scenarios. And it's interesting because although the health department is very significant in size, we didn't have a lot of post-employment issues, and I think that was for a few reasons. Number one, it seems that a great percentage of the people who work at the health department either stay there until retirement and truly retire, or they transfer to another state agency where the government-to-government exception applies. Also, there was a fair amount of education in terms of information provided during onboarding, also education during the term of someone's tenure at the department, and also when they left. And in addition to that, and outside of the post-employment restrictions, I'd like to think, and I think that there was a culture in the department of being cognizant of ethics issues in general with regard to the code of ethics while you're employed at the department. So I think, once ethics issues are brought to the forefront with people, they know that, hey, here's an issue, let's talk to someone about it. So I think that culture probably helped with regard to individuals after leaving state service. So for example, I was always happy. We would get inquiries, even when someone who was employed at the department, their spouse was working at a private entity that would appear before the department. Those department employees would come to us and ask for an opinion on how they handle things like that. So that was rewarding. But two anecdotal stories that did come to mind, which I'll share with you. They came to my mind for a couple reasons. Number one, I knew the people involved. And number two, they sort of pinpoint or show that people tend to get angry when you raise an ethics issue with regard to their activity. And so one of the stories was someone who I had worked with outside of the legal department had left. There was a successor to that person, obviously. When the employee left the department, he went to private industry, and then he proceeded to email his successor trying to coordinate between the department and his private entity. And the successor contacted me. That person was actually new to state government, said that this doesn't seem right. There were multiple occasions where the emailing had occurred. At the time, I had consulted JCOPE because it seemed like a clear violation. And they suggested, among other things, that I send this person an email instructing him to please stop and that it's an issue. So a little bit awkward because I knew the person. I sent an email and I got back a response saying, Jim, number one, you're being overly cautious, and number two, you don't know what you're talking about. So I let the folks at JCOPE know, and they took it from there. And one comment, one comment too for people in state government, and the way I always viewed it, with regard to JCOPE and the Inspector General's office, I always viewed both of those agencies really as a partner in terms of compliance, because when you're in a state agency, you don't want any problems, and if there is a problem, you want to make sure that it's fixed and addressed appropriately. And that's exactly the roles of both of those agencies. I think that in large part, both of them have an educational function as well. So it's Some people, I think, have a knee-jerk reaction. Let's not let them know. Let's not do this. And I think it's actually the exact opposite, because the more you interface with those agencies and work with them, the fewer problems you'll have, and people will be educated in a better way. The other story that I have, so that first story was the 2-year bar. I have another story related to the lifetime bar, which is a little bit, has a little funny twist to it. So when I was general counsel of the state health department, it's a large bureaucracy. A lot of times I would get calls from people on the outside, hey, Jim, XYZ is caught up somewhere in the department. Can you help us shake it loose? And sure, let's find out where it is and see what we have to do. And shake it loose in terms of making a decision, not necessarily one way or the other. So I had received a call like that from someone who had worked for the department. I had worked with this person. Their 2-year bar was over. They raised the issue. I said, yeah, sure. So one of the attorneys who worked with me, I asked her, you know, I've got this call. Can you please find out where it is, and let's try to, you know, get this resolved. So the attorney did some work on this, gathered some information, and then we had a meeting at the health department. In legal, at least, we always spoke of the program employees and legal employees. So the program employees being folks who aren't in the legal office. So we had a meeting with myself, an attorney who worked with me, and someone from the program staff on this issue. And in that meeting, the attorney from my staff raised an issue that, hey, Jim, the person who called you to shake this matter loose, I found this letter that this person had signed when he worked for the department. You know, I think it's a lifetime bar issue. And it's interesting, just the dynamics of being in an agency. Based on information, it was a tangential letter. I didn't think it was the same matter. There were some other, you know, factors where I didn't think it was an issue. But sort of the dynamics of having coworkers, I didn't want to, you know, shoot my coworker down in front of the program person. I said, okay, you know, it might not be this, it might not be that, but let me look into it, or I'll deal with it. It was a Friday before I was going on vacation. So when I spoke with these two people, I said, hey, let's do this. I like to try to deal with things in a practical matter if I can. So I said, let's do this. You know, if the person calls back while I'm out, you know, just don't return the call or say, hey, Jim will call you when he gets back. Because my game plan was to talk to this individual and say, hey, listen, this issue came up. I don't think it's an issue, but let's avoid the issue altogether. How about if you need to follow up, you just have someone else from your office call me? It would have been, you know, no problem, done deal. So I got back from vacation, you know, on day one, and I'm sitting in my office, and my assistant said, and I'll, you know, use a fake name, my assistant said, Steve Smith is on the phone for you. And Steve Smith was, and it's a fake name, but Steve Smith was somebody who, you know, was working in the department. And so I pick up the phone. Hey, Steve, how you doing? It wasn't Steve Smith. It was this other Steve, and I didn't know it. And all of a sudden, I hear somebody yelling at me, how dare you tell my staff that I'm unethical? And I'm like, what the heck's going on here? And I'm trying to figure out who is this on the phone, and then finally I realize it. And I said, you know, I didn't say that. You know, I don't know where you're getting that from. And it turned out that the program person who was in our meeting, for some reason, I don't know why, ended up calling the former employee's secretary and saying, listen, you know, we can't talk to him about this because he's violating the ethics law. So that was a bit of, you know, it was a bit of a tough conversation with some yelling back and forth for a little while, but then we finally resolved it. So, you know, those are some anecdotal stories. And with regard to a personal experience in leaving state service, I think a number of things are important. Number one, there are a couple of ethics opinions with regard to discussions with potential employers. So anybody who is thinking about leaving state service, obviously you want to be well advised with regard to those opinions and make sure that you follow the law and the guidance on the same. When I was leaving state service, one of the things I did was I literally printed every single advisory opinion with regard to the 2-year bar and lifetime bar, and I read through every single one of them, and on the top, I wrote notes with regard to what the opinion was about, what the holding is, and I can't tell you how valuable that has been to me. I have them in 2 red welts in my office, and when I have an issue, and I remember, I remember there was an opinion on XYZ, and I can thumb through and look at my notes and figure out, you know, what the guidance has been on that. The other thing that I did was, excuse me one second. The other thing I did for my current employer, people who aren't in state government, first of all, ethics issues with regard to people who are in state government can be complicated and confusing at times. For people who aren't in state government, it's even more of a, can be more of a foreign issue. So for me, what I did after I read all the opinions, I created an outline in terms of this is the law with regard to what I can and can't do, and I gave it to my current employer. So from managing the situation from my standpoint, then I had given something to them so someone, it reduced the likelihood of somebody from the firm coming to me and say, hey, Jim, can you do X, Y, Z? So I tried to educate them a little bit with regard to what the law was to prevent the ask to begin with, just because of a lack of familiarity. So also, I had the pleasure of dealing with a lot of people from JCOPE when I was general counsel at Health. Those issues more so dealt with the code of ethics, you know, at that point in time. But when I left, the other thing that I've done is I've really used them as a resource in a number of ways. If during my 2-year bar period, for example, there are times, so in terms of an appearance before your former agency, there are a lot of things that can constitute an appearance besides showing up and saying, hi, how you doing, or sending a letter. There's also guidance out there, or advisory opinions, that if you have a reasonable expectation that certain work of yours, even though you don't submit it to your former agency, could end up there, that can be an improper appearance. So with regard to various factors, including the lifetime bar factors, what I would do is, if I didn't think I could do it, I would do my own analysis. I would say no to a potential client or no within the firm. If it was a matter that I thought I could do it, I did my research, and I thought that it had the potential for an issue. Even though I thought I could do it, I thought I was well within my rights. If it was something where I thought, gee, somebody might analyze this in a different way, or if I thought, one difficult thing is, a lot of people out there don't know the ins and outs of the ethics law, so you could be doing something that's appropriate, they think it's inappropriate, and they contact JCOPE. So what I would do, if I was in a situation where I thought there was the potential of that, I would contact JCOPE with regard to that too, just because I would want the scenario where if they're going to hear about this, I'd rather have them hear about it from me first as opposed to somebody else and then scramble and try to figure out what the facts are. With regard to guidance from JCOPE, I've done a number of things. I've done the gamut of just speaking with someone on the phone to get their take on it or to confirm that my analysis is correct, or having them send me an email confirming that I can do X, Y, Z. And then in one instance that was had more importance, I asked if they could please provide me a informal written guidance or written opinion with regard to it. So for the folks in state service, you know, obviously you know this, but especially for attorneys, you know, your reputation is everything, and better to be safe than sorry. The folks at JCOPE are there to provide this assistance. The last thing you would want from a reputational standpoint is to have someone read about you in the paper or something else. So I think it's important. It's painless, and the resources are there to make sure you get it right. So, thank you.
Okay. Good afternoon, everyone. I'm Ruth Moore. I'm the Executive Director of Cornell Cooperative Extension, Dutchess County, just north of here. I'm going to follow Richard Rifkin's lead and say that anything that I say today or opinions that I take do not necessarily reflect opinions of my organization. It makes me feel better because my board signs my no conflict of interest form every year, allowing me to do presentations like this. I have left state service once, well, actually twice, because I worked in Massachusetts state government and then came to work in Albany. And left state service in Albany in 2012. And I'd like to share, as you've heard already, some of my experiences and observations, both as a general counsel for a state agency, the Department of Agriculture and Markets, and then as a consultant briefly, and finally as an employee of CCEDC, which is a subordinate unit of government. In each of these positions, as much as I did work with JCOPE and its predecessors, questions arose where I would not know the answer, consult with them, and then provide advice to employees, or I would have questions myself after I've left state service. So I'm going to touch on the 2-year bar, an example, the lifetime bar, and the government-to-government exception. As general counsel at Agriculture and Markets, from about 2007 to 2012, I had among my responsibilities also as acting as the ethics officer and the liaison to first the Ethics Commission, then the Commission on Public Integrity, and finally the Joint Commission on Public Ethics, JCOPE. And I dealt with cases of employees, as Jim did, leaving state service and sometimes appearing or attempting to appear before the agency. And it ran a sort of a gamut where employees did it right in most cases, where they checked if they had any concerns and did not appear before the department if there were some concerns. And then employees who checked and were told, no, what you're proposing to do would violate the 2-year bar, and adhere to that. And then the employees who didn't check, got caught, faced potential fines. In those cases, I was checking with JCOPE and typically was advised that we should write a letter with a warning and then go from there if they didn't heed the warning. A lot of times it would make the current employees at the agency quite uncomfortable because it sometimes, maybe usually, started with a colleague that had left. I'm calling to find out about your family, and then it would segue into something related to an appearance. So I was always appreciative when employees came and said, I've got this issue with Joe, for example, who just retired or has gone into private business and is starting to cross the line. So the takeaway for me from those situations was, for employees, was to follow the process, protect yourself, consult with your ethics officer and or with JCOPE, and get the advice in writing as needed. You may need it later on, too, not just when you immediately leave. With respect to a lifetime bar, in 2012, I left state service and I did some private consulting with a marketing and communications firm on a number of issues, but primarily on a project in another state relating to research and messaging on an environmental cleanup. And the firm, like my work, wanted to hire me full-time. I was considering that and some other options. But one of the firm's major clients in New York was in the midst of a protracted, contentious case with DEC, where I worked from 2006 to 2007 as deputy commissioner, and it had to do with an environmental cleanup. I was not involved in that project, but I had covered one public meeting when all the people working on that project were unable to do so, and I had general knowledge of the case because I was on the executive staff. out of an abundance of caution, I contacted JCOPE to see if I could take that position, and I did receive a verbal opinion that the lifetime bar applied. Now, I know that the bar is very fact-specific, but based on my presentation of what I did at DEC, I got that opinion. And because of that, and I was weighing other things at the time, the prospective employer and I mutually agreed that it would not be a fit if I could not ever work on anything related to their major client. So again, the takeaway, don't presume that because you may have had what you thought was minimal impact that you don't need to check and that it might not be an issue. So things worked out. A few months after that, I was offered the executive director position at CCEDC. And this anecdote is the government-to-government exception example. People familiar with cooperative extension? If you're not, I see a couple of heads going up and down. We are a research, education, and outreach organization, nonprofit. We work in agriculture, the environment, health, nutrition, and wellness, and we run the 4-H Youth Development Program. Any 4-Hers in the room? So we are considered a subordinate unit of government. The relationship, and Cornell University, the state side of Cornell, is our parent. So we abide by rules and regulations that they provide, but we do have independent boards of directors in each county that govern the day-to-day and oversee the day-to-day work of each association. The relationship between Cornell and state and federal and local governments and our associations are set forth in State County Law 224, and that's how we run our business. To me, having worked with extension associations when I was at Agriculture and Markets, it was a given that these were subordinate units of government. Regularly, employees may have left my department and gone to extension associations throughout the state or worked on the state side of Cornell. So government exception applies, right? Well, about a year in working with CCEDC, I was approached by a state official to take on a project for my former agency that was very site-specific in Dutchess County, and it dealt with all the things we worked on: agriculture, the environment, food, nutrition, and wellness. And I did not think there would be any problem. It was a government-to-government exception. I would call the agency for information from time to time. So we took on the project, but a few months into the project, some concerns were raised by another state official that there was a problem there, that there would be, I would be violating the 2-year bar. So there was a momentary pause in my participation in the project. It was cleared up. There may be now, if I missed it, but there was no formal JCOPE opinion at the time about the status of Cornell Cooperative Extension as a subordinate unit of government, but it is in state law. And it was helpful at the time that this was going on that I located a Second Circuit Court of Appeals decision written by Justice Sonia Mayor before she ascended to the Supreme Court bench, saying that another extension association was in fact a state subordinate unit of government. So we got past that, but the takeaway for me was I should never presume, out of an abundance of caution, get it in writing whenever it occurs, and do look at all the old opinions that are still valid. It's also my experience, though, too, and in this new wonderful manual, that thinking does evolve over time based on some cases that come before JCOPE. And it's always wise to actually go back, even after you've been out for a while or you think you have something settled, when you're making another move, to make sure that there aren't any issues that have come to light in other cases. Thank you.
Good afternoon. My name is Kate Siebert. I'm the Deputy Director and Counsel for the Legislative Ethics Commission. First and foremost, I want to thank you for staying with us. It's a unique opportunity to be the last panelist speaking for the day. It's even more unique to be talking about something that doesn't apply to a majority of people in the room. So stay with me, and we'll get through this. For the Legislative Ethics Commission, we work very closely with the Joint Commission on Public Ethics because of this unique bifurcated process of their being the enforcement agency for the members that we provide advice and guidance to. And the recurring theme today, I think, has been how important advice and guidance is to get through these times and to get through these ethical situations. Specifically for this, for post-employment, we have kind of apples and oranges for the post-employment. You guys were talking about subject matter, backroom. We have direct versus indirect lobbying as our restrictions. So for members of the legislature who leave state service, they are prohibited for 2 years from directly or indirectly lobbying either the Assembly or the Senate, regardless of where they came from. For legislative employees, and again, like yours, it applies to anybody who collects a paycheck, they are prohibited from directly lobbying the legislature for those 2 years. So for us, the kind of trick is to determine indirect versus direct. And it's sort of similar to the back room versus the other portion of JCOPE's prohibition. So for us, we actually have an opinion. It's on our website. It's a generic opinion. And it kind of talks over what is indirect lobbying and what can you do when you leave state service. Because again, the goal is not to prohibit people from finding jobs and from being able to do what they learned to do. It is kind of to prohibit that access or that appearance of some sort of special treatment. So for a lot of individuals, there's many things that they can do. And at the LEC, we really encourage people to call us and talk to us before they leave state service so that they know the things that they can do. We've gone so far as to speak to prospective employers about what people can and can't do. So for us, our main goal is to make legislative employees and members aware of what their restrictions are while they're here. Because you don't want somebody to leave state service, take a job, and realize once they're there that they can't do the duties that they were hired to do. So we do extensive training. Statutorily, the houses are responsible for ethics training. The Assembly does their own, the Senate does their own. They graciously allow us to participate in that training because it helps them since we are the ethics people. So we make sure that all of that training includes extensive post-employment instruction. In addition to that, any employee who is hired by the legislature has to take an online quiz within 30 days of being employed, and that quiz introduces them to these post-employment restrictions. The Assembly actually has done something which we think is great, and on exit interviews, they go over the post-employment restrictions so that when people are walking out the door, they're reminded of these restrictions. And we actually continue to work with them, like you guys talked about. You know, a year into it, they'll call us and they'll say, hey, we're looking to do this. Is this something that we can do? And we will talk them through it. Is it directly lobbying? Is it indirectly lobbying? We also have the government-to-government exception. So if you do leave the legislature, you can go ahead to another governmental entity and this post-employment ban would not apply. Now, for the legislature, it's also very unique because they are only prohibited from lobbying the legislature. So regardless of being a member or an employee, they can leave and lobby the executive. They can leave and lobby the state agencies. So it is strictly lobbying the legislature that the statute prohibits. So like I said, we actually spend a lot of our time helping people to navigate through the post-employment restrictions so that they can find that place to go to. We always tell them in our training sessions, we certainly don't want you to leave state service, but if you do, here's what you need to do, here's the guidelines you need to follow, here's our phone number so that you can continue to call us, you can continue to work with us. We've had situations, again, somebody talked about earlier where you want to kind of cut it off before somebody asks the question. So for example, We get phone calls, we get snitches too. We get phone calls from people who say, I saw Joe and he was in the Capitol at Dunkin' Donuts and he was having coffee at Dunkin' Donuts. And we said, well, was he lobbying at Dunkin' Donuts or was he just standing in the Capitol at Dunkin' Donuts? Lucky for us, we already had spoken to Joe. We know what his capacity is. We know what he's doing now. So it is beneficial also for people to talk to us, and in the situation of state agencies, to talk to the individuals at JCOPE so that they're aware of what you're doing, what your plans are, and they can, one, guide you through it, and two, cut it off if somebody is making a complaint or if somebody is alleging you're doing something that you're not. So mine is short and sweet because, again, as I said, it doesn't really apply to people in the room, but I did just want to point out some of those differences and kind of mirror what everyone has been saying today about the importance of education, the importance of reiterating these ethics rules to people so that they're aware of them.
Well, thank you. I want to thank all of the panelists and the keynote speaker, also Richard Rifkin and Seth Agata, and the staff at JCOPE for putting this together and for putting together the wonderful desk book. Let me remind you that for those of you getting CLE credits, the certificates are outside. There are several people helping out there. The table is broken up by alphabet. There'll be lines. So please be patient, and you'll get your certificate before you leave. Thank you all, and thank for the wonderful panel. Thank you so much.